Counsel, when you're ready.
Good morning, Your Honors. Ben Cuney, appearing for Carlos Rodriguez, whose convictions for second and third degree murder and resulting life sentence are the subject of this appeal. I would request 4 minutes for rebuttal, if Your Honor allows. The appeal raises a number of evidentiary issues, including several of constitutional significance. For purposes of my primary argument, I will be focusing on the first 3 issues. The court is aware of the factual circumstances. Suffice it to say that Mr. Rodriguez was convicted at trial of 2 counts for the same offense, a second-degree murder and a third-degree murder for the same victim, same offense. He was acquitted of aggravated battery of another victim. He has raised on this appeal a confrontation clause violation by nature of the allowability of a surrogate gun residue expert to testify as to the expert report of an absent gun residue expert. This raises a confrontation. Only scientific connection of the gun to Mr. Rodriguez's hand. His surrogate, who was an assistant at the office, who as a third peer review on the report, but conducted no analysis of the report, and her own independent investigation and analysis did not duplicate the critical finding of the one and an in-trial in limine and confrontation clause violation. And that admission at trial of Dr. Niemeyer's report without Dr. Niemeyer being present to be confronted about his and his alone conclusion and analysis, not participated in by the surrogate witness, and whose
But counsel, hasn't our Supreme Court already passed on this issue in Smith versus State? Didn't they find that the testimony of a supervising witness who offered an opinion based on data generated by a team of analysis was okay in certain circumstances? And in this case, this particular witness was present for the work that was done by the witness who was unable to be there because he was having surgery. And she she contemporaneously co-signed the report with him. So you've cited other cases where this type of thing would not be appropriate, but the facts of this case seem to fall pretty squarely within the ambit of the Smith versus State opinion. And this seems to be something, I've been a judge for 23 years. I did this as a trial judge. This is a kind of a fairly routine thing. This is not unusual.
Your Honor, we have cited both the Smith versus State case and the Callaway versus State case in our briefs. Smith versus State holds to the very proposition that Mr. Rodriguez has advanced as a confrontation clause violation. But what is critical, and Your Honor mentioned it very specifically, there are some factual issues that need to be determined in assessing the confrontation clause violation for a successor witness. And in Smith, these were the critical factual determinations that allowed a confrontation clause objection to be overruled. And there, and I quote, the surrogate witness testified, and I quote, "I draw the conclusions. I interpret the results. I write the report and testify," end quote. And then that surrogate testified as well, quote, "I do the interpretations and all the conclusions based on their work," end quote, and then describe the team approach whereby analysts actually do the lab work and all the analysis was done by the testifying witness. Here, quite contrary, we simply have a sign off for peer review purposes. Was the process done according to our standards? With the witness testifying, she was, well, number one, didn't even recall being present when the particular analysis was made, and she did not replicate that analysis for purposes.
Well, what she did recall, though, she did recall the having conversation while this was being done with the person who was doing it. She specifically did recall that. So it's not like she doesn't recall being there, but she did, because she was having an ongoing dialogue with him. He was reporting to her everything he was doing.
And that's correct. That was testified to, although with regard to the critical issue of his analytical finding for the particular particle. And note, her own effort to find the gun residue was unsuccessful. Therefore, she introduced Dr. Niemeyer's report, not hers, and she was able to, as the testifying witness, essentially explain why her report could differ and would differ scientifically from the hearsay report prepared by Dr. Niemeyer by saying, well, he reviewed it first, and the process of doing that analysis could have resulted in my analysis not being complete because of the heat function.
So let's assume you're correct in all this. Does it really matter in this case? Because this was not a damning piece of evidence. She repeatedly said during the course of her testimony is, just because we find this residue, where we find it doesn't mean that this person is the shooter. She said that repeatedly. In addition, we have a lot of evidence here identifying your client as the shooter. We have 2 eyewitnesses who specifically identified him as the shooter, among a bunch of other evidence, including the gun was found, the place that he went over the fence and where it was seen by the witness. There was a magazine found in his apartment that matches the gun that was found. I mean, there's a lot of evidence. So let's assume you're right. And this witness herself said, this is not the end of the day just because we find this residue. It doesn't necessarily connect them. So this is like harmless error if I've ever seen it.
The state does argue harmless error. Mr. Rodriguez has addressed that by pointing out that, yes, there were witnesses to the shooting. This was the only evidence that scientifically connected Mr. Rodriguez to the actual gun and the act of shooting. The only scientific
except for the witness who testified said this doesn't necessarily do that. She said that.
Granted, she testified to that based on the hearsay conclusion of Dr. Niemeyer. We believe because...
I apologize for interjecting. I just wanted to clarify something. Can you point me to the page where his report was actually admitted into evidence? I recall that Dr. Jocelyn testified about the report, but I don't recall if the report itself was actually introduced into evidence.
Your Honor, she testified as to the conclusions stated in the report. She read those conclusions and stated those conclusions. Her report, she testified about as well. So the conclusions raised by Dr. Niemeyer were put into evidence by the prosecution through this witness. And she iterated for the first time, the only time, what Dr. Niemeyer's conclusions were. Ergo, she introduced the substance of Dr. Niemeyer's report into evidence. We believe that it's not harmless on this record. Moving to the second issues, Your Honor, of the constitutional double jeopardy violation, it's quite clear Mr. Rodriguez could not be convicted of both count the second-degree murder and the third-degree murder for the same offense. The question
And nobody suggested that he could. I mean, a matter of fact, it was the state that brought this issue forward to the court, correct?
Yes, Your Honor. And under the case law, the remedy chosen by the judge was, first of all, incorrect because the
Well,
judge is
except
not
for
allowed.
once again, we've done this in other offenses, such as dealing in stolen property and grand theft. We do it all the time, and it's handled exactly this way.
Your Honor, respectfully, not quite. The remedy for a conviction for an offense that is either merged into, as this one might be, or double jeopardy is not simply to release the adjudication or rescind the adjudication. The judge is required to make a judgment on that count, either to find the defendant as a matter of judgment not guilty or to dismiss the count on the basis of double jeopardy or merger. Here, that count of conviction of guilty remains on the docket. So a remedy at least has to be to not only vacate that offense, but to enter a judgment of not guilty for either merger or double jeopardy. But on
Except
top,
the court's ruling was to withdraw the adjudication on that count, correct? And
And-
no sentence was imposed.
correct.
So
and
help
that
me
is-
with this nuance that you're raising, that it appears on the record, but it also appears on the record that the court did not adjudicate him on this and did not sentence him.
Correct, Your
So
Honor.
help me with this needle you're trying to thread.
Not necessarily needle, but respectfully, Your Honor, Murphy versus State makes clear the options available to the trial judge, and it concludes a judge can't simply refuse to act on the judgment. A judge must enter a judgment on all counts. Here, there is no judgment entered of because it was rescinded of guilty or not guilty. That matter has to be referenced by the judgment. So at least as a matter of correction, this court must direct the trial judge to enter a judgment of not guilty for merger or double jeopardy. Getting to the issue of double jeopardy, the position advanced is that Mr. Rodriguez was tried for the same offense twice, giving the jury two opportunities to convict him of the same offense, the same shooting that led to a death. That itself putting the defendant on trial for the same offense in two variants is, as we've argued, a double jeopardy violation that should preclude.
But as you know, this is done all the time. This is not an unusual occurrence, and the law has supported the doing of this for my entire career. So what is new in the law that now makes this no longer viable?
Your Honor, the Ball versus United States decision that we cite says that curing a double jeopardy violation before adjudication does not remove the double jeopardy consequence of facing jeopardy for multiple offenses. That's the constitutional violation that Mr. Rodriguez raises, in addition to the remedy that was not properly implemented by the trial judge. The third issue, Your Honors, that we have focused on deals with the closing argument, both in specific fashion and cumulative. The most principal violation of which was subject to an immediate contemporaneous objection, was the prosecutor telling the jury, and I'm quoting, and this is on transcript page 740. Now that all the evidence is in, the presumption of innocence has vanished. It's gone. Sitting right here is the guilty man. It doesn't show on the record, but presumably pointing to the defendant. That principal objection, that is not only completely wrong, that is an absolute violation of the burden shifting. The presumption of innocence lasts through and including the deliberations of the jury. And in this particular case, there was no presentation of evidence by the defendant. Adding to that clear violation of the presumption of innocence, and frankly, a departure from the jury instructions given to the jury, the prosecutor also asked the jury to put themselves into the defendant's shoes and ask why the defendant would act a certain way when the defendant did not testify, did not offer any testimony, and did not have any confession that he challenged in the course of the trial.
But all
The
the
prosecutor
evidence, all
said-
the evidence that the prosecutor was referring to in this context had been put before the jury. And this is not a golden rule violation because he's not asked, or the prosecutor has not asked for the jurors to place themselves in the shoes of the victim. They merely have said, why would a person do this? Okay.
Correct.
So I'm having a hard time with that violation also. I don't see that a golden rule violation. It seems fair comment on the evidence to me.
Your Honor, the prosecution's comment at page 681 says, ask yourselves why someone who did nothing wrong would force police, would hole up in the apartment for over 3 hours and force police to essentially use tear gas to get them out, end quote. That puts Mr. Rodriguez on trial for having not given his explanation of why he, who did nothing wrong, would force the police to do something. That is precisely the comment asking the jurors, directing the jurors to ask why the defendant who did not testify would do something. That's not based on the evidence in the case. It's based on the lack of evidence. No answer from the defendant to that comment. And
Mr. Cuny,
additionally,
I just
the
wanted to let you know you're at, I'm sorry, I wanted to let you know you're at 15 minutes, sir.
And Your Honors, to close on this point, the prosecution also commented on the failure to surrender. As we know under the Fenelon test, flight and fugitive status are not admissible unless the prosecution goes through an extraordinary burden not found in this case. And those three comments made in seriatim as a feature of the prosecution's case undermine this case, where in our last issue, just to briefly address on the sufficiency of the evidence, this was an impulsive shooting without any knowledge between the defendant and the victim or victims. This was a classic Bellamy versus State brawl that resulted in an impulsive overreaction among strangers that is almost always sufficient to support a manslaughter, but not sufficient to support a second-degree murder, depraved mind. And noting in the murder 3, which was vacated for the trespass and insufficient establishing of any possessory interest in the place where the offense occurred. For all those reasons, we ask the court to vacate the convictions and remand for a new trial for evidentiary reasons or for due process purposes, or at a minimum, instruct the trial judge to enter a judgment on the murder 3 count. Thank you, Your Honors.
Thank you. Mr. Hurley, when you're ready.
May it please the court, Jonathan Hurley representing the appellee, the state of Florida in this case. Starting with the first issue, the state would submit the trial court did not err when it denied the defense motion in limine with regards to Dr. Jocelyn's testimony regarding the January 18th GSR gun residue report co-authored by she and Dr. Niedermeyer. Factually, the court found that Jocelyn was sufficiently involved with the testing process. She reviewed the raw data. She oversaw and affirmed Dr. Niedermeyer's findings and conclusions. Those are her that was the court's factual findings. The ruling by the court is that this did not violate a confrontation because the defense would be able to effectively cross-examine Dr. Joslin about her own independent conclusions regarding the initial 2018 January GSR report, which she co-authorized. Now, the record supports this finding. Joslin testified she worked closely with Dr. Niedermeyer during this time because she was in essence Dr. Niedermeyer was going to be retiring from the company that does the testing, and Joslin was going to be taking over the role of the head analyst for GSR testing. That's the background. While she did not specifically remember in this particular case setting up the tests and actually looking into the electron microscope, she testified, as Your Honor mentioned, Niedermeyer told her everything that as he was doing it, told her everything that he was doing. Joslin also observed Niedermeyer prepare and initially photograph the samples used for this testing in this particular case. Joslin reviewed the raw data generated by the machines to ensure that the data was accurate and was consistent with the report's findings. Joslin reviewed the photographs, Niedermeyer's notes, spectrum that were in the file in this particular case. Based on these materials, Joslin formulated her own independent opinion affirming Niedermeyer's
Mr.
findings.
Hurley, if you don't mind, I'd like to move to another issue that I am concerned about. And the one I'm concerned about is a prosecutor standing in front of a jury saying to the jury, the presumption of evidence is gone. Why don't you address that issue? That one concerns me. So what could possibly support a prosecutor making a statement like that in the presence of a jury?
Well, Your Honors, I think that as you had mentioned earlier, that the prosecutor in this case was simply the evidence had already been presented, and the prosecutor was simply summarizing that evidence. And
but is the presumption of evidence gone at that point?
The presumption.
I mean, the presumption of innocence, is it gone at that point? I mean, is that a correct statement by the prosecutor?
I don't believe that's the correct statement, but again, I think that the prosecutor here was simply summarizing the evidence as presented. And
well, isn't it misleading to the jury for the prosecutor to stand there under the color of representing the state of Florida and misinforming the jury as to what the law is on this most vital area?
The state does not believe so, Your Honor.
Well, I would expect that, but help me understand why you don't.
Yeah, please explain.
Well, in this particular, as I just mentioned before, this was mainly a summary of the evidence as presented. And I think in that context, when you take the totality of the prosecution's closing, in this particular facts, the state would argue that that did not in any way deny the defendant a fair trial based on these particular facts.
So are you saying that it was just an inartful way of saying that the presumption of innocence had been rebutted?
Yes, Your Honor, that would be a fair characterization. Going back to the initial confrontation clause, just to touch on what the Supreme Court ruled in Smith, when examining the confrontation violation, it's essential basically to examine the role of the surrogate and played, and as well as evaluate when evaluating the lab result. So when you analyze the facts and apply it to Smith, in this case, it seems clear that the evidence would support the trial court's finding. Also, from a side point, just stepping back, the purpose for this evidence was to really explain why there would be a discrepancy between the initial tests and the second test. So arguably, this didn't even raise a confrontation clause issue. That this was not admitted for a purpose of stating a fact, that this was really admitted in the context of a 9704 admission, in that the Johnson was simply using the data from Dr. Niedermeyer in trying to explain why there was a discrepancy. Mind you, that the initial particle that was characteristic of gunshot residue in this case was
Mr. Hurley, can I redirect you again, please, sir? Because you're spending a lot of time on this issue. I'm afraid you're going to miss the other issues that I'm actually more interested in, okay? And the other issue that I'm concerned about is these two murder charges, a second and a third degree murder charge. They're tried, and basically the jury renders a verdict, state stands up, says, judge, you can't convict them on both, you got to pick one or the other, and they do all that. It's your opposing counsel's position that that wasn't enough. More needs to be done, that the judge should have rendered a verdict on that second, on the third degree murder, not just simply withdraw the adjudication and not sentence, and that there's a record that'll forever be out there showing that the jury convicted on this. He also raises the point that these should not have been tried together because it gives the state two shots at the defendant on a murder charge based on the same factual scenario. So help me with those.
Yes, Your Honor. First of all, double jeopardy does not prohibit the state from prosecuting a defendant for multiple offenses in a single prosecution. Instead, it protects against the cumulative punishments for convictions of the same offense. This court in Clapp versus State said that a jury verdict imposes no punishment. So just because there was a verdict, that does not mean that the defendant was punished. The record shows that the trial court rescinded or vacated the third degree conviction during sentence. So that is a matter of record, that the trial court did in fact vacate that third degree conviction during the sentencing hearing. Also, the written judgment only shows the conviction for the second degree. Not surprisingly, it's arguably the defense waived any double jeopardy claim. On the record, the defense counsel was asked specifically, do you have any objection to the way it was handled? And the defense said, no, it did not. Also, this was this second degree murder conviction was a PRR life conviction. So there wasn't even a score sheet prepared in this particular case. So we don't even have a record of a third degree showing up on a score sheet for that matter. So the fact that the jury unto itself had a verdict of guilt, that is not punishment. The record's very clear that the trial court vacated that third degree conviction.
Mr. Hurley, you muted yourself.
Did you hear the last portion?
No, I did not.
Okay, excuse me. The record is clear that the trial court expressly vacated that third degree conviction during the sentencing hearing. The second degree was a PRR life felony, so there was no score sheet even submitted by the state to even show any other convictions. So what we have is a record showing that the trial court vacated the third degree conviction. There's no judgment there's no written judgment in regards to any third degree conviction. So for that matter, so basically the count has been vacated and there's no double jeopardy violation. Moving on to just to touch on the last or the fourth issue regarding the JOA and the sufficiency of the evidence. You have the evidence as presented you had a couple of things. You had victim, you had evidence in the record of prior conduct between the victim and the defendant. Santos, eyewitness Santos testified that there was the victim and the defendant were engaged in a verbal and physical exchange prior to the shooting, and that Woodson testified that the defendant was attempting to go after the victim. The victim was also, there's eyewitness testimony showing that the victim was shot while running away. And the defendant was observed not only pointing the gun in the air, but pointing the gun at the victim's running away. Based on that evidence, that would be legally sufficient to get through the JOA when it comes to malice and intent and so forth.
Mr. Hurley, you're muted again. Were you finished?
Lastly, Your Honor, with regard to the closing comments, as Your Honor mentioned, this was not a golden rule violation because it was addressed. Golden rule only pertains to the victim, not the defendant in this case. This was not commenting on any silence by the defense. You had a situation here factually where the defendant fled from the crime scene, goes back to the Paradise Inn. The witnesses described the defendant fleeing. You had another eyewitness who saw the defendant shortly after the shooting come back to the Paradise Inn. The evidence showed that basically the defendant holed himself up in his apartment at the Paradise Inn. All the other residents of the inn were called out by the police on loudspeaker to come out. There was a standoff for 3 hours. The evidence is clearly sufficient to demonstrate that the defendant knew he was being called to come out and was simply avoiding prosecution by failing to surrender. This was not an instruction as addressed in the Fennell case. This was simply evidence that the prosecutor was able to comment on to properly draw the attention to the jury to consciousness of the guilt from the defendant for failing to come out for 3 hours. Thank you, Your Honors.
Okay, thank you. Mr. Cuny, you got about 3 minutes left of your time.
On record page 740, virtually the last words the jury heard from the prosecutor, right before the judge began jury instructions, the prosecutor said, in violation of the law and in violation of the burden of proof, now that all the evidence is in, that presumption of innocence has vanished. It's gone. Sitting right there is the man who committed the murder of Kelsey Engelson. Sitting right here is a guilty man, end quote. Defense counsel's immediate objection. The judge ignored it.
But to think about this, and I want your help with reconciling this. The standard jury instructions require the judge to basically instruct otherwise and instruct that the defendant has the presumption of innocence, and that presumption remains with him through each stage of the trial. That's exactly, I've given it so many times, I can do it in my sleep. That's what the judge tells the jury, okay? Why doesn't, I mean, the judge is the authority in the room. Why doesn't the judge's instruction control? And because the judge gave an instruction, that's in the nature of a curative instruction.
Except, Your Honor, respectfully, we know what the jury instructions are. This prosecutor knows what the jury instructions are. This is a murder case. How many times, and there's no record evidence of this, but how many times was this prosecutor prosecuting murder cases? To say flat out in violation of all the law and the jury instruction what the law says about the presumption of innocence. And the trial judge, Your Honor, respectfully, if the trial judge has said, now wait a minute, Mr. Prosecutor, jury, disregard that statement. I'm going to instruct you on the law. then there might be an issue of whether that curative instruction was appropriate. There was no curative instruction. And in fact, the judge's comment, again, and it's important to note the timing, page 740, the judge's only concern was, quote, "We need to be done," end quote. The judge was anxious to move this case to closing argument, to jury instruction and jury deliberation. Not a
Was the curative asked for by defense counsel?
Your Honor, no, because the defendant said, "Objection, Your Honor, may we approach?" The judge refused, said, "We need to be done." And the prosecutor moved on. Last words said, judge began the jury instructions. The defense attempted to correct this. And note, this was a reasonable doubt case. The entirety of the defense closing, pages 694 to 732, read it. This was a standard burden of proof case. The prosecution hasn't proven beyond a reasonable doubt the evidence of guilt. And
Mr. Cuny, I'm sorry to cut you off, but you're at the end of your time, sir.
Thank you, Your Honors. We asked the court to order the relief as requested in the briefs.
Thank you both. All right, next on our docket this morning is Stahl versus Boca